Prosecutors say, how dare you? The Latah County Prosecuting Attorney's Office has asked the judge to schedule a jury trial for this summer in the case of Bryan Kohberger. A date has not yet been set, but Kohberger's attorneys filed a motion last week, on the 31st actually, requesting to move the trial out of Latah County. Now, the attorneys for Bryan Kohberger argue that a fair and impartial jury can't be found in Latah County due to the extensive inflammatory pretrial publicity, allegations made about Mr. Kohberger to the public by the media that will be inadmissible at trial, and given the small community, the salacious nature of the alleged crimes, and the severity of the charges. Now, that was all in the motion. She wants to enlarge the jury pool and will have to do what they can to overcome the pervasive prejudicial publicity because Latah County does not have a large enough juror population to avoid the bias in the community. Probably right. Well, the Latah County prosecutor, Bill Thompson, responded in his motion filed late last week saying that the request is premature and without a sufficient basis. He notes that the defense has not provided the court with adequate information to conclude that the Latah County jury could not fairly and impartially decide the defendant's case. And the motion noted that the Idaho appellate courts look at several factors when determining whether a trial court exercised its discretion in deciding a motion to change venue. That would include affidavits indicating prejudice or an absence of prejudice in the community. Thompson also wrote that the other factors considered are whether the defendant challenged for cause any individual jurors, the nature of pretrial publicity about the case, and the duration of time between the publicity and the trial itself. And Thompson notes that, hey, because publicity is not a standalone reason for a court to change venue, this court should decline to grant the motions filed by the defense, and a trial date should be set to adequately hear the facts and decide the case. Mr. Thompson asked the court to set a trial date for a hearing on the Kohberger motion for change of venue and another date be set, that being a trial date. And that will also trigger witness deadlines that need to be set as well. So what does this really mean? I'm surprised. Normally, change of venues are due promptly if you think it's in the wrong venue. What does that really mean? Normally, a district court where they handle felonies is a court of statewide jurisdiction. So if you commit a murder in County A, you can say, well, yes, I've been charged in County A, but the appropriate venue for the crime is in Venue C. Move the case to Venue C. Change of venue. Crimes normally need to be charged where the crime occurred. I have a similar case like that right now, but I like the venue where the matter is charged now. I would prefer that jury over the jury in Venue C. It's a tactical decision. Then you have change of venue where you cannot seat a jury. We talked about this extensively over the years. Normally what takes place is that a judge will make a determination that they will not be able to seat the appropriate number of jurors. Oftentimes they wait because, as we've seen in lots of high-profile cases, there are lots of people that have never heard about a case or maybe have heard about it but paid little to no attention of it. You would be surprised. A lot of people just don't follow the news. They don't want to hear bad news, so they don't follow any crime type of issues in the newspaper or on TV, let alone on Facebook or YouTube. So you're going to be able to find people that can say, yeah, I can be fair and impartial. Only if you can't seat enough jurors in a small jurisdiction, that's what needs to be done. Now remember, in the Lori Vallow, Chad Daybell case, they moved it because the judge said, listen, I'm moving this thing. Everybody in town knows about it. I'm basically taking judicial notice of the fact that everybody is talking about this and we're not going to get a fair trial. So they moved it up to Ada County. More than likely, that's what will take place in this particular case. I get it. The prosecutor is going to object. No, we can have a fair trial here. This is where the crime was committed. The people want to know, be able to see what takes place, etc. Chances are most people have heard about it. chances are most people in Latah County have formed an opinion as to whether Bryan Kohberger is guilty. Remember, it's not just that you know about it, but that you have formed an opinion about the particular case. And if the jurors say, I am willing to listen to the evidence, reserve judgment until I hear all the evidence in the case, then I am also willing to follow the law that the court gives me in the jury instructions, they can be a fair and impartial jury. I think the case will get moved probably to Ada County, Boise, just like they did in the Lori Vallow matter. Next on the docket, to maybe a little more redeemable individual, yes, a boy. Look at this. Look at this video. A young boy, I think he's 9 years old, called the cops on his mom because he found drugs. So take a look. This little boy, 9 years old, handed police in the body cam videos a massive bag of methamphetamine that he found under his mom's nightstand. The little boy looked, apparently had locked himself into the bathroom and called the dad. Now, we're not talking like this kid's living in the slums or anything. This house is worth almost $500,000 there in Las Vegas, in Henderson, Las Vegas to be exact. Anyway, when the kid goes into the bathroom, he FaceTimed his father, who then called the police. Guess what? The kid stayed in the bathroom till the police showed up. And when the police arrived, they knocked on the door. And the kid brings them the methamphetamine that he had found. Of course, the mom denied any knowledge of it, but it turned out it was about 100 grams or about 3.5 ounces of meth in the house. Now, all this took place back in July of 2022, and the footage was finally released. Now, Kendra Long, the mother of the child, was arrested on drug trafficking and child abuse charges, and she told the cops that she had no idea how those drugs got there. Well, maybe she used some of that alleged drug money to pay her $25,000 bail. They got her out, and guess what? During some of the legal proceedings, prosecutors showed text messages that Miss Long knew she was in fact dealing drugs because they said, hey, do you want to come over and buy $100 worth of drugs or an ounce? Anyway, the boy's parents are divorced, and the child is under the care of the father. Lori Vallow 2.0. Remember, Lori Vallow has that second case pending in Arizona, and, well, guess what? There's going to be a trial. This time, she's facing the 2 counts of conspiracy to commit murder, and Ms. Vallow faces the charges after she was extradited from Idaho late last year. Lori Vallow is accused of conspiring to kill her previous husband, husband number 4, Charles Vallow, who was killed by Lori's brother, Alex Cox. Alex Cox shot Charles Vallow at the residence, and he claimed it was self-defense. Cox himself then died of natural causes before the police ultimately figured it out that, hey, things just didn't quite make sense at this particular crime scene. So, as a result of an alleged conspiracy between Alex Cox and Lori Vallow, she now has these charges of the conspiracy to commit murder. She also has charges of attempting to kill her niece's now ex-husband, Brandon Boudreaux, who survived after being shot at multiple times while returning from taking his kids to school. It was later discovered once again that old Alex Cox was the alleged shooter. And coincidentally, on the whole Idaho thing, Alex Cox was more than likely the person who actually killed the children. Lori Vallow and Chad Daybell allegedly conspired and maybe convinced Alex to do that. But anyway, Alex is no longer with us. He can't really defend himself. But hey, we know he did shoot Mr. Vallow. So next, the court has scheduled February 21st. The court will hold a hearing for the complex case scheduling order. Now, remember, the prosecution moved to continue the previous trial date, which was set to start next month. Coincidentally, the exact same time that Chad Daybell was supposed to start his trial for the death of his wife, Tammy Daybell, as well as for the deaths of JJ and Ty Lee. The prosecution said, hey, we got too many witnesses that coincide with that case. We can't do it. The judge granted the complexity finding, and so the case was basically put on hold. Well, now the trial management conference is going to be set for July 5th, and a new trial date has been scheduled for August 1. It could get moved based upon the complexity issues. We'll have to wait and see. And as you know, most people know by now, if you follow Crime Talk, Lori Vallow was convicted in Idaho of the murders of her children, JJ and Ty Lee, as well as her husband's previous wife, Tammy Daybell. So she's not going anywhere. She's got a lot of time on her hands. What are the prosecutors doing in the Delphi homicide case? Remember, they have a double homicide that took police some 7 years to make an arrest, mostly because of some filing paperwork errors on the part of the FBI contract employee. They're getting spanked early in motions practice, and it makes the prosecutors and the police not look so great. But as you may recall, remember the old new attorneys on the Delphi case? Well, now the prosecutor wants to hold them in contempt of court for the attorney's friend/former employee removing items from their law office. And guess what? There's going to be a hearing on March 18th, and the prosecutor is going to call witnesses to bolster their allegations of contempt of court against the two attorneys representing the Delphi suspect, Mr. Richard Allen. So the prosecutors over there in Carroll County, a guy by the name of Nicholas McClellan, filed a notice yesterday indicating that he has shared with Allen's attorney the names of the witnesses and the exhibits that he is going to present in front of the special judge, Judge Francis C. Gull, as it relates to the contempt proceeding. And I'm sure Judge Francis C. Gull will find the attorneys in contempt. They have all but said, I guess we should have done a better job. Who would have thought that a former office employee / friend would have taken photographs without our knowledge while they were left alone in the law firm? Is that contemptuous? Yes. Now, normally when something like this takes place, it is at the end of the proceedings. It's at the end of the case, and then they say, okay, by the way, now we're going to deal with those contempt proceedings against the attorneys. Why are the prosecutors trying to do this? Is it because they don't want these attorneys on the case? Because they're spanking them around maybe a little bit? I think that's it. You would think these prosecutors that, frankly, if you look at the filings, and I get it, the judge dismissed it, but when you read it, you think, yep, I have some doubt here that Mr. Allen, giving him the presumption of innocence, but if what they say he did in the amount of time that he did it, he clearly wasn't acting alone. Doesn't relieve him of any criminal liability if a jury believes that he is in fact the killer. However, it makes you think that maybe the investigation was a little flawed. So I would think the prosecutors would be focusing more upon preparing their case and getting the case to trial so there are no further delays in this particular matter. But no, they want to have a contempt proceeding as it relates to the attorney. I wonder if the judge has done that, put that suggestion into the prosecutor's heads to move forward on that. The prosecutor additionally asked Judge Gull to order the attorneys, Brad Rozzi and Andrew Baldwin, as well as their attorneys, a guy by the name of David Hennessy, to share their witness and exhibit lists before March 7th so that there's no delay. The judge hasn't made any orders just yet, but more than likely that's what will take place. Now, as you may recall, Mr. Allen is charged with the murder and kidnapping back in February 13th of 2017 regarding the deaths of Livy German and Abby Williams. They were allegedly abducted from the hiking trail near the Monon High Bridge east of Delphi, Indiana, and then killed on the north bank of the Deer Creek about a quarter mile from the bridge. Their bodies were found the following morning. Nearly 6 years later, police arrested Allen. Now remember, Mr. Allen went to the police shortly after the case started, the investigation started, and said, hey, I was in the area, and the FBI, through their crack team of investigators, misfiled it. And then 6 years later, they're like, hey, we're going to take a fresh look at this, and Somebody realized, hey, did anybody look at this piece of paper shoved in this file over here? Hey, we should probably go talk to this Richard Allen guy. Anyway, this case, let's just say it has been somewhat highlighted by the legal bickering between the prosecution and the defense, and not to mention the judge and the defense. Now, the judge in this particular case got spanked by the Indiana Supreme Court for her conduct, whereby she dismissed Mr. Rossi and Mr. Baldwin basically without cause, and really didn't like that. And so then she summarily denied motions that normally would require an evidentiary hearing. At least you would think so, given the nature and the specificity that was laid out in those particular motions. But the court denied it on the paper, on all fours, and said that was it. So there's been a lot of animosity there. Clearly, it runs not only from the judge to the defense, but the prosecution to the defense. And the prosecution's clearly looking to establish their dominance in this particular case by filing the motion for contempt. So we'll see how that goes. But you would think the prosecutors, mistakes happen. Like when prosecutors accidentally turn over stuff that they shouldn't have, or they turn it over late. Geez, maybe they should be held in contempt. Don't you think? Well, of course not. They're just the government. They're just a bunch of good old guys in white hats doing their job the best they can with limited resources. And we just can't be doing that. But the defense makes a mistake. Oh, boy. What are we going to do? Throw them in jail for 6 months? That's one way of doing it, I guess. Anyway, the judge did deny the motion to recuse herself in this particular case, given her actions. It was denied. No indication that the defense has appealed it. I think they're just going to go forward and say, let's go to trial.